Hello, Philly landlords. What's up? Today we are doing our third episode of the Philadelphia Landlords Connect podcast. And we have an amazing guest, and I would like to introduce him. Chris Dean is a Glenside native and has been living in the city since 2009. He is an attorney who works in Philadelphia. He started out studying criminal justice at Temple University, so a true Philadelphian in all ways. And that got him interested in law and eventually in getting a law degree. But even before that, he interned at the Special Investigations Unit of the Philly DA's office, where I'm sure he had an incredible experience that provided him with a lot of background into many things in law and later in real estate and all the things that we have to deal with as landlords and working with tenants. During law school, he interned at the Montgomery County District Attorney's Office, and then took a job after that at the same office. That's correct, Chris, right? I'm not botching this up. And he graduated in 2000. When he graduated in 2010, he was working at the district attorney's office, where he was able to gain invaluable courtroom experience. After several years, Chris decided, he worked in several law firms where, I'm sorry, I'm botching this up. He moved to a small real estate firm in the city where he transitioned into the field of real estate law. And Chris's experience runs the gamut from ejectments, evictions, title issues, breach of contracts, all of the many, many, many things that we have to deal with whenever we're involved in real estate. Chris gained further experience during doing work in government collections, and had the opportunity to oversee sheriff sales, which I'm sure was an incredible way of learning about investing and the whole process of becoming an owner and a landlord. In 2019, he took the leap and he started his own firm, and that's where we find him today. His expertise covers a wide range within real estate, from sellers backing out of deals to ejecting squatters, fraudulent deeds, mistakes on deeds, and all kinds of things that he's already told me about that really make him an incredible resource. He recently got married and has shared some exciting news that he's expecting his first child in July, and he's got a rescue pup that I have to ask, what's the rescue pup's name?
Haley.
Nice.
Didn't name her, but we kept it.
Okay. So I thank Chris for joining us and spending his time and sharing his vast amount of knowledge. Today, we're going to focus on liability and leases and how landlords can and should be protecting themselves. So without further ado, here's Chris Dean, and let's just start out about telling us a bit about how you ended up here where you are today.
Thank you for having me, Cheryl. Listeners, I hope this is a learning experience for everyone. One thing I forgot, I didn't tell you beforehand. You mentioned the true Philadelphia experience. What really also propelled me into law, while I was in college and even in high school, was I really got the true Philadelphia experience. I was shot at when I was 18.
Oh my.
It didn't hit me. And then my car was stolen by a 13-year-old while my freshman year at Temple. So I knew I was going into the right field.
Okay.
And I knew what to expect. Yeah, Philadelphia. I'm pretty jaded at this point.
But you're still here, and that's what's important.
I'm still here. So you mentioned my last job. I worked for a national firm based out of Texas that many people, listeners, may be familiar with Linebarger. If you go on a real estate tax website, sometimes they'll say your taxes are being collected by GRB or by Linebarger. Linebarger actually does a lot of the vacant lot sales for U.S. Bank in the city. So for 3 years there, I got to run title reports, file lawsuits against property owners, defend the city when people try to challenge the sale, work with investors when they buy a property at sheriff sale and someone tries to challenge that sale. We would kind of work side. We represent the city, but really we'd be helping the investor out to protect the integrity of that sale.
So, so can you talk about a lot of, I think a lot of landlords, the only time a lot of landlords come into contact with an attorney is when they reach the point where they need to evict somebody. And I once had an attorney tell me something that I thought was very wise. It was something to the effect of, you know, talk with me before you have the problem. Don't wait until you are faced with some problem and then you're calling me in an emergency. So can you talk a little bit about like for this, a lot of our listeners are smaller landlords, they're just starting out. People are afraid of even talking to an attorney because they think that's going to mean that they're on the clock and they're going to have to start spending a lot of money. So but at the same time, attorneys often save us from being in situations where we're either being sued or just something happens that's going to cost us quite a bit. So can you talk about some of the reasons that people who are in landlording and involved in real estate might be well served to start from right now, start talking with an attorney and getting that proper consultation?
Sure. There's a lot of I guess there's misconceptions about attorneys. There's people get scared of the word retainer. How I work and how many attorneys work is if it's a new client and they might give you a retainer, general representation. So I represent several investors where they give me the initial retainer. It's not a crazy amount of money. They bill hourly, and as we build a relationship, there's no re-upping the retainer. It's, hey, you got this project. I need to evict someone here. I have a promissory note here. I'm trying to assign my lease to someone here. We just do it, case by case. So there's no giant retainer that has to be replenished. I work on an a la carte basis. So, and a lot of attorneys do work that way. And so that the financial part scares people. A lot of people, a lot of the things I see, especially on Facebook and social media, new investors especially, they maybe are jumping ahead too far, and they find themselves in a pretty horrible predicaments if they have a troubled tenant, a troubled property with the city. So when someone approaches me, and why it's so beneficial to have a lawyer up front is I'll do background. So I will, first thing a client comes to me, they say, I'm thinking about renting, this. Can you create a lease? Well, who's the person you're looking for? I do a judgment check right away. And I think so in my own personal, my wife and I, we each have an investment property. Knock on wood, it's been smooth sailing for me because I spent so much time up front vetting who is going to be renting our homes. And not there's and a lot of the it depends, and it is price contingent. So if you have lower income rent, sometimes you don't have that benefit, and you might have to take a chance on someone. But a quick search of the Philadelphia Municipal Court is at least the bare minimum you can do. You don't even need a lawyer to do that, but lawyers obviously have logins, know how to navigate, have background checks, and that doesn't take that much time. Half an hour you could spend on a lawyer, and it could save you hundreds and thousands of dollars down the line if you have someone who has a very troubled eviction history. And other things too, if you're acquiring a property, a lot of investors will acquire property and it comes with tenants. Let's look at the property. I do a background on L&I for rent. I will see, hey, you have 10 open violations. There are things sometimes the title company won't check. Title companies will do a search on they'll do a search on the recorder of deeds, but sometimes there's active litigation that they don't know about because it's on the dockets, but it's not on the recorder of deeds. So having an attorney up front is great for background. You can really see what you're getting into, and it is good investment. You're not going to have to spend thousands and thousands of dollars right away if you have, hey, I just need some help to navigate whether this is the right home for me and this is the right tenant for me. And then, probably once you get past that threshold, creating a lease. If I were to say the most important thing in creating a lease, especially in Philadelphia, because Philadelphia, no matter what your lease says, you have to follow a lot of rules. So your lease can be a clause that's not going to be held up in court. If you try to shift everything, responsibility all on the tenant, in Philadelphia, it's just not going to matter. But So many people contact me, and this is not just in real estate, but they say, "Hey, I want to sue and I want to get my attorney fees paid." You cannot in Pennsylvania get your attorney fees paid, with slight exceptions, but in the real estate world, unless your contract says you can get your attorney fees paid. So that's usually the number one thing when I review, um, when I review a lease. If I'm creating a lease, and I do commercial leases as well, you have to put clauses in there that you will be entitled to a reimbursement of your attorney fees. Otherwise, a problem tenant just becomes that much more expensive for you.
Right. So I think, I mean, the leases are really obviously a really important issue for tenants, and so a lot, I mean, for landlords, and a lot of I've seen a wide range of leases being implemented by either management companies or individual landlords. Some people use the, forgive me, I don't remember what it's called, but there's a standard lease that you can download from the Pennsylvania Real Estate
AFG
Association,
card.
right? So is that good enough? Do we need to add amendments? Like, how do we, and does every landlord, does it depend on their individual situation? What are the things that we need to take into consideration when we prepare lease? Or should we even have a different lease for each tenant?
Uh, that lease is, I mean, frankly, it's fine for 66 of the 67 counties in Pennsylvania. Philadelphia not being
Oh,
not being the one. Um,
that's
now
a that's a great thing to know. I appreciate you're letting us know that.
it's a fine lease. If you use that lease, you will want to do an additional add tons of additional terms and addendums to it, depending on the lease. So a lot of, if you put the lease, if you check this property is as is. In Philadelphia, it's really not going to matter. Courts will find certain terms unconscionable. So if the landlord has, if the tenant, the unfair part is, if you're offering a reduction in rent for the tenant to take on more responsibilities around the maintenance, it's really not going to matter in Philadelphia. So I'd advise any prospective landlord, don't offer a concession for them to do for the tenant to take on more work or more maintenance on the property, because it's not going to really matter. And you're just robbing yourself of additional money, because the court's not going to really care. The court cares about, is the property, first of all, do you have a written lease? Do you have a rental license? And do you have any, well, are there any L&I violations? Obviously, you need a certificate of rental suitability, and now you need the lead test to go with it in every zip code in the city. Those are the only things they really care about. And so many times, the tenant will, everybody, landlords hear the word Fair Housing Commission and it makes them cringe. And I used to go there frequently, especially before COVID, and it became a place where, yeah, you shrivel when you walk in, because the tenants oftentimes, they'll put. I had a case where a tenant, 90% sure, a tenant punched holes in the wall and just said they magically appeared, call LI, the property's violated. And then my client tried to evict them, and they're now getting prosecuted by the Fair Housing Commission. And this is not like the rest of the state. The rest of the state does not operate this way. So Philadelphia is completely separate from the rest of the state when it comes to landlord tenant law.
So a case like that where a tenant is saying there's holes in the walls and they magically appeared, and we all know where they came from, and he moved into that house presumably when there weren't holes in the walls, and he's saying like, I mean, these are all intelligent people who understand, what's going on here in those sitting in those sessions. But what is it that they're assuming happened that the in a case like that?
I believe in that case they were claiming that the house was not, it was not, the lock didn't lock properly, and they were blaming someone breaking into the home.
Okay.
Um, so it was really far fetched. And not that it can't, not that the problem is, a few bad apples ruin everyone. So a couple of troubled landlords created a ton of trouble for, the honest landlord. And most landlords only have a few investment properties and are stretched thin, and they're doing it just to make an extra buck, and grow. And those few bad apples have kind of created all these protections for the city. I mean, for these tenants. And you have so many. So in that situation, I would advise, it gets to that point, I advise if it's feasible, do a cash for keys, 30 days. Let's file in the court and actually make a judgment by agreement. I do this a lot for ejectments too. Ejectments, ejectments especially.
So
You
can
can
you can you tell us what an ejectment is as
first.
opposed to an eviction?
So ejectments are your typical you have squatters. So the typical scenario is you acquire, and back when sheriff sales were really rampant in the city, they really have slowed down, obviously since COVID. Um, People buy properties. There's people in them, so they're either complete squatters or they're the former owners or former tenants, and so you don't have any landlord-tenant relationship, and you have to get them out. A lot of times, I see posts just offer cash for keys. That's fine, but if that person doesn't move out, you have no tool to get them out. You have to file the ejectment. So I will tell clients, even if they want to do cash for keys, file the ejectment. And of course, it costs money. I mean, even the filing fees with Philadelphia are going to cost you around $400. You file it, and then we make an agreement right away. The tenant signs it. It's a court. We get it approved by the judge. So if hey, we'll give you 30 days and $2,000 to move out, and they don't do it, I can then take that order we have with the court already and go right to the sheriff's office.
Okay, so that an ejectment is actually a harder process to go through than an eviction,
Yes,
even though it's somebody who's basically broken into your property and taken it over illegally.
that's right.
And
And they did create an emergency. It's similar to an injunction, a TRO. It's called a temporary restraining order. Especially, you can basically file an ejectment. You can actually ask for special relief from the court, schedule a hearing immediately. Um, they're not successful much though. I had one. I told my client, hey, it's going to cost you probably a couple grand to file this emergency motion. Um, it's you if it's usually when it's clear someone broke into the property last night. The police won't do anything about it, and you serve them, and then they have to come to court. If they have no valid say, if they don't come with a fake lease or a utility bill in their name, there's a chance the court will grant you that emergency relief. But in most cases, they will not, because so many of these people are crafty. They'll just call the water department. They'll get a bill in their name, or they'll call Pico. Usually it's Pico. They'll call, or they'll come up with a fake lease. I've had fake leases presented to me, and I had to wait. I had a client, we had to wait a year and a half, go through a trial, completely unnecessary trial, and my client can't get any attorney fees, cannot get any of her court costs back. And this person just put a fake lease together, and it wasn't with my client, even wasn't with a former
oh,
owner.
doesn't it have to have the correct name on it? It doesn't
It was
matter.
no. This person claimed that they were a victim. They gave somebody $10,000 who said he was the owner. Whether or not that was true or not, it's just my client is out probably $5,000 in a year and a half of her life, all because of that. So in Philadelphia, you have to, if you start from the ground up, you really have to. People who buy properties, I mean, I'm very weary of taking of any property that's occupied. If I would steer clear unless you're confident you spoke to them. They're actually going to enter. You have all their contact information. They're going to enter a lease with you. All of that. I would tell most of my clients is to tread lightly, and in most times just steer clear of any occupied properties.
Okay, so and just in terms of protecting ourselves, I guess a lot of people are always concerned when they have a vacant property and what they should do. So other than the obvious of try to secure it as well as possible, maybe have an alarm. I don't know if that even helps, because I don't know, if the alarm goes off by the time the police come and somebody's already in there. What steps, if any, can we take to try to reduce the risk of having squatters or an ejectment situation?
Boarding them up is really it. Monitoring it, getting a vacancy license too, if it is vacant. Because that's further proof that if they try to come and say, "Oh no, I have a lease with this person," you say, "Well, I have a Why would I have a vacancy license if I paid for a vacancy license? Why would I have that if I had a landlord-tenant relationship with you?" That's good evidence for in an ejectment case.
Okay. So that's something I never even thought about personally. And so if I have a home that's not being lived in currently, and I do get that vacancy license, which actually is kind of expensive, right? It's more than a rental
It
license.
is. So I
But
would
it
only do it if it's going to be a long term.
okay.
You're in between tenants. It's probably not. It's not worth it.
Okay. And by reacting quickly. So if I have an alarm or for whatever reason, I go and check my properties frequently and I see that somebody has gone in there. If I can beat them to the punch where because it would take them time to get utility bills into their name or something like that. So is time of the essence with that?
Time's of the essence, and policing it. You have to if you're an out of county investor, out of state, you need to have someone. You need to have eyes and ears on the ground. I mean, you don't have to have someone watching it 24/7, but you want to have someone who can go there at a moment's notice within a half a day, in case there is an issue. You need periodic checks because if there is anything, because if you let a property go for a bit, um, you can at least document. You can have someone going by, hey, take pictures. Wait, it looks like my boards are removed. Investigate, take pictures inside, so you can have that paper trail that you will need, and you will need it if you have to actually go to trial in one of these ejectments. And oftentimes you don't need to go to trial. But for instance, I was a few minutes late with you because I had just I have a client. We have an ejectment. My client was a bona fide purchaser, and that is actually a defense in Philadelphia. So if you buy property through title, pay fair market value, and someone tries to challenge it, who is let's just say an heir, let's just say you bought it from an estate. One of the heirs says, no, that should have been my property, and they defend the ejectment that way. As a bona fide purchaser, you're protected. So their beef is with the person who sold the property to you. But if you bought it with title insurance, you're going to be protected. So I just learned that I had a lockout scheduled for February for a client. We already paid the sheriff, and the court postponed my lockout without a hearing. I just got notice of an ex parte order, so I didn't have a say in it. And he filed a petition to open up my judgment that I had from 4 months ago, to try and fight our case, even though he has no say. I didn't get notice of the court, so I had basically until the end of business today to get an emergency response to fight this, to continue with my lockout. If I'm unsuccessful, my client's gonna have to pay the sheriff again $325, and all because this guy is making up claims that have nothing to do, nothing to do, even if he's right about his claims, nothing to do with my client's rights to the property. So it just goes to show you, and you have to, in this case, we had proof that this client, this squatter, wasn't living at the property. We had pictures, we had process servers documenting property looks vacant, feral cats around, and he was claiming he's going to be homeless. He's not really living there at all. So documenting all of that stuff in this situation should help my client.
And are a lot of these squatters often represented by some kind of free legal service, or how are they fighting this?
A lot of times,
on their side?
A lot of times they are. I've had to battle against CLS, Community Legal Services, and I do have a fine working relationship with them. I mean, they do valuable work for the people who do need it, but occasionally they'll get duped by someone who has a made up story. I will say this: if you're buying, because this case, client was buying from a state, so I had two problem cases for clients in the last 6 months, who were buying from a state. So if you're buying from the administrator of an estate, you really need to make sure all of the heirs were properly notified. If it's because you could have someone coming from the woodwork and say, I didn't get, my brother stole that property from me, and he didn't pay me any compensation. And then now you're dealing with fighting the brother. And like in this case, that's exactly what happened. And our argument is that that's between him and his brother. He can sue his brother separately, the estate, for not offering him any compensation. But in Philadelphia, I might have to. The court may force us to go to trial, which would back my client up another 2 months.
Mhm.
So if you're buying from an estate, really, really be careful. I would even ask to review the estate documents with a lawyer to make sure it was a valid estate.
So in this case, if the client had done some work prior to the purchase, he may have been able to avoid this situation. Is that?
He could have. If I were the client, he could have looked at the deed history. For instance, in this instant case, the person challenging it actually owned the property one time, and it looks like he transferred it to another family member within the same year, and then that family member died, and then someone became the administrator of that estate. I would look at the deed history, so that's one thing I would do. Hey, wait a second, it looks like the one, there's a family member, one of them just deeded it to the other for $1, and he wasn't the administrator at all. I would probably want to even contact that person to
Mm-hmm.
see, to make sure, because the estate file will have, if there was a renunciation. So you have to renounce your renunciation is when if you're picking the administrator, and it's, you say you have 3 siblings, somebody volunteers, and the other 2 say, I'll renounce my rights, you can do it. If I saw a renunciation in that case by this one challenging, and I say, okay,
Okay.
fine, he did it.
Is that something that a title company could have or should have picked up on, or is that beyond their expertise or
Beyond,
role?
it's slightly beyond, only
Okay.
when challenged. And that's where an attorney would, I do a lot of estate work too, but that's where an attorney would, it's very unusual situation, but that would be my go-to with an estate. I would say,
Okay.
let me
Good.
do the
Good to
paperwork.
know. And so let's turn a little bit more to the liability issues. We're all always worried about, well, the common thing that people talk about, like slip and fall. And somebody once told me, because I invest in a lot of areas, and somebody once told me, pay attention to the billboards on the highway as you drive into the area where you're interested in investing. And are most of those billboards about, injury attorneys and things like that? And if they are, just keep that in mind, that that's the environment you're getting into, possibly. So I don't know personally how, Philly is, and if there's a lot of that, and on the other side of things, how do we protect ourselves best, aside from making sure that our properties are, steps are intact and we have railings and things like that?
I'll give you a nightmare scenario that happened to a client of mine. And so it starts with, I mean, if you have homeowners insurance, you're going to be protected for the average slip and fall. There's more often than there's so many, especially depending on the parts of the city, depends what you paid for it, but a lot of property owners who still don't have homeowners insurance. So a lot of wholesale deals, you'll see it, or it's slip and falls happen when it's, hey, I just acquired it 2 months ago, I just haven't gotten a policy on the home yet. I had a client who the city's always secondarily liable on every slip and fall on a sidewalk in the city. So what that means is the city has a duty to notify a homeowner if there's a crack in their sidewalk that could cause a problem. If they don't, then they're secondarily liable. So I had a case where my client, he owned a property, slip and fall, there was a crack in the sidewalk. The city didn't they didn't police the sidewalk. They didn't send him any notices of correction to cure the defect. But we ended up, before trial, the city ended up settling it for $50,000. That's usually that's the max that the city usually will go on these cases. And there actually were serious injuries. So what happened was the city, though, then they're the co-defendant. They have a judgment against the homeowner, my client. My client didn't tell me, and I think deliberately didn't tell me, that's always some clients should always tell their attorney everything, because the good and the bad, because I can protect them better if I know information. My client had several other properties out of county, and the city hired a great. He wrote the book on collections. Long story short, the city got reimbursed $50,000 because my client was selling another property in out of county. Didn't inform me at all. The city got wind of it, and they went to closing and collected $50,000, all the proceeds from the sale from my client, because, well, frankly, he didn't disclose it, but because he didn't have any insurance at the time of the injury. So your general homeowner's insurance will don't cheap out on it, because if you have other assets, you could be subject to execution on your other assets.
Okay. And there's an ongoing battle among investors about whether to have properties in an LLC or to get umbrella short insurance. Now, I'm not saying it should be one or the other. Maybe it should be both, but and I'm sure it depends on the personal circumstances of the landlord or investor. But what are some of the things that we should be considering when we think about, should I put my properties in an LLC? Is it okay to keep it in my personal name and then have an umbrella policy?
I would say, frankly, I would say it depends. I keep my properties in individual names. The reason is, for one, if you do, one common misnomer out there is people are always looking for exceptions to transfer a property from themselves to an LLC or vice versa. You're always going to pay transfer tax. So people are always looking, there's only one exception if it's farmland. So if you own a farm and you put it into an LLC, if it's on the farmland, you can do that without paying
Right.
transfer taxes.
Well, a lot of people are concerned about if they're using financing. So it's always easier to get financing, or not always, but the best rates are for traditional loans that you can get in your own name. So I think that's one of the things that people are trying to understand, and how to balance the two concerns.
So, and an LLC is fine. So if you, a lot of actually law just changed on holding companies. So a lot of, if you're a real estate investment company, and that's all your one LLC does, your holding company even. There was just a recent case, actually, it happened in 2022. The Pennsylvania Supreme Court held that even your holding company, so a lot of companies will, okay, I'll put this property in an LLC, I'll put this property in another LLC, and on this one another LLC, and one holding company. Now, all every single one of your companies can be attacked. So if you have a judgment against one company, the holding company is not safe anymore. The Pennsylvania Supreme Court just on a ruling just ruled that last year. And the reason is, if the test is if the company is doing the same thing. So if I have let's say I own a brewery, and then I have a real estate company, they're not, the brewery's safe from anything that happens at the real estate company. But if I'm putting 5 different properties in LLCs, and one of them gets sued and I just shut down an LLC, all my LLCs are now subject to liability. So putting an LLC, are you personally going to be okay? Yes, in most cases, unless you do something egregious, where you could pierce the corporate veil. In these kind of cases where, hey, there's a slip and fall, there is damage in the home, the LLC is going to be, you're not going to be personally liable. So it really depends on how many properties you have. I'd say if you have just a couple, it's fine putting your name. If you're in the business, of, this is what you do, you have hundreds of properties and you have an underlying holding company, just be aware that now, if all the companies are doing the same kind of work, real estate investment, they are all going to be, theoretically could be subject to a judgment you have on one, even if you close.
Okay, that's a big change, I think, isn't it?
It is. Holding
Okay.
companies usually, yeah, you can never go from one LLC to another, and the Supreme Court last year ruled that you can.
Okay. And for people who have just, small operations and they have a few LLCs, and it's typically somebody might just get an LLC online for, I don't know, $50, whatever it costs, rather than going to an attorney. And from what I understand, they're putting themselves a bit at a risk, because it's not just having an LLC. There's things you have to do in order to make it genuine. Is that
Well, you need
true?
to have a lot of like LegalZoom, and I think NOLA is another one. They will give you a registered. They'll sign you up. They'll sign you up with a registered agent. Most people don't even know what that means, but they are
Right.
entitled to accept service. I've had so many, not so many. I had a few clients who have had judgments against them without even knowing it, because they moved their offices, but through LegalZoom, they set up an office in Allentown. They didn't even, a registered agent, and they never had a forwarding address, so they never even got notice that they were served. So it's much better to have. I file a lot of LLCs for clients. You need a certificate of organization, and if you have a partner, you have to have an operating agreement, and that operating agreement, comes in serious handy in certain situations, especially if you have a partner. If you don't have an operating agreement, I have a case going on, and without too much detail, but there is an operating agreement clause, unanimous consent between partners to litigate. So having an operating agreement protects you if you have a disagreement with if one partner goes rogue and files a lawsuit, that partner now has liability to you, because your operating agreement says so. Without an operating agreement, that partner can do everything, and you're going to be on the hook for all the liability of the company.
Okay. So I guess, I mean, basically it's important. I mean, these are complex structures that we create for ourselves. Owning real estate is a lot of exposure, liability, and always what I tend to conclude is talk to an attorney and, sit with somebody and tell them, here's what we're dealing with. Here's what I own. Here's what I'm trying to do. Here's my concerns. And what kinds of things should I be looking for? Even I have found personally, like, insurance really confuses me. And I've met with all kinds of insurance agents. I used to work with somebody who just, sent me I would tell them, here's the address. They sent me a policy. I would sign it, just assuming they know what they're doing. And only later, and thankfully in time, learned more about insurance through a better agent who actually sat with me and explained everything that I need to be concerned with and made sure that I had the right coverage. But it seems that, we need to add another layer to that. You can't just rely. I don't know what their responsibility, what an agent's responsibility is, but an attorney will really truly look out for our interests. That's all they care about.
And attorneys are held to it's a professional license. So unlike we're, real estate agent, go to the ethics board, but we could have our license, revoked. And we have malpractice for a reason. So anytime there's a professional license involved, there's a bigger duty, I would say, and we attorneys should take that, duty seriously. So I would say, listeners out there, if there's two things you take away from anything I've said, is with your leases, do your homework up front, spend hours digging into a person. I've had people, write up fake letters from a boss who are getting under the table pay. Really dig into them. It's even worth it paying, LexisNexis. You can probably pay $200 to do a search on someone. It really pays off. And always in your leases, always include prevailing party will get attorney fees. Because if you don't, you go to court, and unless a judge grants it to you, you have no contractual way of getting reimbursement for attorney fees, which can add up. You have multiple properties, you can know how fast that can add up.
Right. And I really appreciated you talked in the beginning about your own business structure of offering kind of what you called a la carte services. And I think that's something that is really key here, because so many issues come up with landlords and investors, and that they hesitate to approach an attorney, like I was talking about in the beginning, because they're afraid of fees. But if they know, I have this one specific issue, I just need a bit of consulting here with a professional, that's worth so much, because that whatever it costs them could end up saving them in the future so much. So I think that's good to know. I'm glad we got that out there.
Yeah, I mean, retainers are scary, but I always tell clients, if you're worried about retainer, we'll put a cap on it, and I'll let you know when your retainer is exhausted, and you make a decision, if you want to go forward or not.
Right. Okay. Well, Chris, thank you so much again for spending your time with us. Could you just let people know how they can get in touch with you easily?
Sure. Email is always the best way. Well, my website is cwdeanlaw.com. Again, cwdeanlaw.com. Email is cdean, DEAN, at cwdeanlaw.com. And that's the easiest. I'm checking email, more than I should. So that's the best way to get a hold of me. And I offer free consultations for everything. And I'd be happy if there's something I don't know how to do. I have an attorney who knows how to do it.
Fantastic. So again, thank you. We'll include your contact information in the show notes, and looking forward to talking to you again and going more in depth in some other topics.
Sure. There's a lot out there.
I know. Too much.
Yeah.
Okay. Thank you, Chris.
Thanks, Cheryl.
All right. Talk to you soon.
Right. Bye.